Today we are going to be talking about the history of DC's Open Meetings Act, as well as some recent changes that were made to the act this year. Here's an agenda of what we're going to discuss. So first, as I mentioned, we're going to discuss DC's open meetings laws, including the Sunshine Act, the Open Meetings Act, and the recent changes made to it. And then we'll finish up with a few trending topics in the Open Meetings Act, some issues that we repeatedly get questions on or that we observe when we're monitoring public bodies. Just a brief introduction. The director covered a lot of this earlier in her session, but just in case you missed it, the Office of Open Government, along with the Office of Government Ethics, are responsible for government transparency and ethics under the Board of Ethics and Government Accountability, BEGA. OOG began operations in April of 2013, and we are led by Director Nikel Allen, who you heard from earlier today. OOG interprets and monitors compliance with the Open Meetings Act, which requires, which requires that public bodies provide proper notice of access to and detailed records of their meetings. We provide training and guidance on the implementation of the DC Freedom of Information Act of 1976, which concerns the transparency and availability of public records, and we advocate for government openness and transparency. Additionally, we provide guidance, including formal advisory opinions on compliance with the OMA, and we conduct training and outreach. OOG can also enforce the OMA on the basis of complaints from the public or on its own investigations, and as a last resort, may sue public bodies in DC Superior Court for injunction, declaration, and/or civil fines. And before we talk specifically about the open meetings laws in the district, just kind of a general overview. In 1976, in the aftermath of the Watergate scandal, Congress passed the Government Sunshine Act. This law required federal agencies to hold meetings in public when deliberating on official business. The act was passed to increase the public's confidence in government by allowing citizens to observe the decision-making processes of federal agencies. It ensures that government business is conducted in a transparent manner, and the act generally requires that all meetings of multi-member federal agencies be open to the public. And for a more in-depth discussion of the history of open meetings laws in the United States in general, as well as how the Watergate scandal led to stronger open meetings laws, I would direct you to see a training that the director did earlier this year on June 26th, which was a primer on open meetings laws. The slides will be available afterwards, but we've got a link here both to a video of that presentation as well as the slides that were presented. Okay. So when we're talking about open meetings laws in the district, we are mainly talking about the Sunshine Act and the Open Meetings Act. The DC Sunshine Act is in Section 742 of the Home Rule Act. It's known as the Sunshine Act, and it was enacted on December 24th, 1973. And the scope of the Sunshine Act, as contained in DC Official Code, Section 1-207.42A, requires that all meetings of government entities, including the council, be open to the public when official action is taken. No official action is effective unless it's taken at a public meeting. With regards to records, it requires that a written transcript or a transcription be kept for all DC government meetings, and shall be made available to the public during normal business hours of the district government. Copies of written transcripts or copies of such transcriptions shall be available upon request to the public at a reasonable cost. Now we're going to get into the Open Meetings Act. This is the preamble, which kind of defines the spirit of the act. It's the public policy of the district that all persons are entitled to full and complete information regarding the affairs of government and the actions of those that represent them. This comes from DC Official Code 2-572. And then the rules of construction for the Act. The Open Meetings Act shall be construed broadly to maximize public access to meetings, and exceptions shall be construed narrowly and permit closure of meetings only as authorized by the Act. Prior to the enactment of the OMA, which happened in 2010, the DC Sunshine Act was not considered a comprehensive open meeting law. In the committee report on the bill that led to the Open Meetings Act, the council noted that the district's then existing open meetings law provided only the most basic coverage. And the committee noted that while the statute seemed to create broad coverage for all meetings, it failed to create clear definitions, clear procedures, and specific exemptions. So this led to district public bodies interpreting the law narrowly. The committee further noted that because the law only covered meetings where official action is taken, the result was that many bodies met privately to discuss and deliberate on official actions. The committee reported that it had heard repeated concerns that this could give rise to procedures that circumvented the law and prevented public access to government deliberations. DC Council passed the Open Meetings Act in 2010 in response to growing concerns about transparency and accountability in the district government. Law 18-350, titled the Open Meetings Amendment Act of 2010, was introduced to the council and assigned bill number 18-716 and was referred to the Committee on Government Operations and the Environment. The bill was adopted on first and second readings on December 7th, 2010 and December 21st, 2010, respectively. And it was signed by the mayor on January 19th, 2011, and transmitted to both houses of Congress for review. And DC Law 18-350 became effective on March 31st, 2011. This year, there have been some changes to the act, some of which you may have seen on the news. The council enacted the Open Meetings Clarification Temporary Amendment Act of 2025 on June 26th of this year without the mayor's signature as Act number 826-0086. It has now received law number L26-0024, became effective on August 16th of this year and will expire on March 29th, 2026. DC Act 26-110, the Open Meetings Clarification Congressional Review Emergency Amendment Act of 2025. And so I'm going to be quoting from the act, which states what the council's intent was. To amend on an emergency basis due to congressional review the Open Meetings Act to clarify the definition of a meeting, to provide for a public body's ability to be briefed about potential terrorist or public health threats, so long as no official action is taken, to exempt from the act meetings between the council and the mayor, provided that no official action is taken at such meetings, and to provide that a meeting shall be deemed open to the public if the public body takes steps reasonably calculated to allow the public to view or hear the meeting while it is taking place, or if doing so is not technologically feasible, as soon thereafter as reasonably practicable. And then just a note at the bottom, and we'll discuss this a little bit later, the act also exempts the district's Criminal Justice Coordinating Council from the Open Meetings Act. And next, we're going to discuss some of the changes that have been made to the Open Meetings Act. And I write relevant here because there were a number of changes that the council made, but I have left out certain bits that were just grammatical in nature, or moving things around, but not changing the content. And so first we'll start with the definition of a meeting, which the council pretty much left the same before going on to kind of clarify other parts. So a meeting means any gathering of a quorum of the members of a public body, including hearings and roundtables, whether formal or informal, regular, special, or emergency, at which members consider, conduct, or advise on public business, including gathering information, taking testimony, discussing, deliberating, recommending, and voting, regardless of whether held in person, by phone, electronically, or by other means of communication. And this comes from DC Official Code 2-5741A. Now, council added that for the purposes of the Council of the District of Columbia, the term meeting means a regular or additional legislative meeting and committee meetings where votes are taken. The council had concerns that the pre-existing definition left some ambiguity with regards to the council's activities, and so this was their fix for that. And so this is now DC Official Code 2-5741C. And then, as mentioned just a moment ago, the Criminal Justice Coordinating Council was added to the list of entities that are not public bodies for the purposes of the OMA. And that new section is 2-5743G. Now, with regards to amendments to 2-575, which kind of covers open meetings, generally a new paragraph 4 was added to read that the public body takes steps reasonably calculated to allow the public to view or hear the meeting while the meeting is taking place, or if doing so is not technologically feasible, as soon thereafter as reasonably practicable. Additionally, subsection B8, which discusses the closure of a meeting or a portion thereof, was amended as follows: to discuss and take action regarding specific methods and procedures to protect the public or a public body from existing or potential terrorist activity or other substantial dangers to public health and safety, or to receive briefings by staff members, legal counsel, law enforcement officials, or emergency service officials concerning these methods and procedures, provided that disclosure could endanger the public or the public body. Yes, question in the back.
Was this changed? What was
I had anticipated that there were going to be some of those questions. So this one substantively is mostly the same as the pre-existing portion, but the council did remove a portion at the end with regards to a record of the closed session is made public if and when the public would not be endangered by that disclosure. So here the main distinction is that the council removed that specific language regarding closed sessions. Okay. The council also added a new subsection H. This title shall not apply to a meeting between members of the council and the mayor, provided that no official action is decided at the meeting. This was one of the more kind of reported changes to the law. The council had concerns that it could not have the kind of frank discussions with the mayor's office that it felt was necessary to do its job. And they have added this to allow for such meetings to take place between the council and the mayor. Additionally, subsection F was amended as followed. Notwithstanding any provision of this act, the council may adopt its own rules to ensure the district's open meetings policy, as established in section 402, is met with respect to gatherings of council members, provided that, unless the council adopts rules pursuant to this subsection, this title shall apply to the council. And now, with regards to this provision, the council was already empowered to make its own rules regarding compliance with the OMA. They made a small tweak here. The prior language specifically said council meetings, and so the council has tweaked this to say gatherings of council members to kind of give, I believe, a broader scope, because the council felt that meetings was a very specific activity that they were doing and did not encompass everything that the council might do together. For instance, they discussed being able to go on field trips together to gather information, things of that nature, which they felt is better kind of encapsulated by using the language gathering. Okay. Amendments to 2-576 regarding notice of meetings. The first paragraph was amended to read as follows. Notice shall be provided when meetings are scheduled and when the schedule is changed. A public body shall establish an annual schedule of its meetings, if feasible, and shall update the schedule throughout the year. A public body shall attempt to provide notice as early as possible, but not less than 48 hours or 2 business days, whichever is greater before a meeting. And continuing with 2-576, notice of meetings, paragraph amended as follows. When a public body finds it necessary to call an emergency meeting to address an urgent matter, and notwithstanding paragraphs 1 and 3 of this subsection, notice shall be provided at the same time notice is provided to members and may be provided pursuant to any method in paragraph 2 of this subsection. And the council also amended 2-577 regarding meeting procedures. Paragraph 1 now reads, reasonable arrangements are made to accommodate the public's right to attend the meetings, or steps are taken that are reasonably calculated to allow the public to view or to hear the meeting while the meeting is taking place, or if doing so is not technologically feasible, as soon thereafter as reasonably practicable. Excuse me. And paragraph 3 was amended to read, all votes are recorded. This particular paragraph previously discussed roll call votes specifically, and now it just has been clarified to state that all votes are recorded. And the last section that was amended, 2-579, regarding enforcement authority. Section A was amended to read as follows. The Office of Open Government may bring a lawsuit in the Superior Court of the District of Columbia for injunctive or declaratory relief for any violation of this subchapter before or after the meeting in question takes place, provided that the council shall adopt its own rules for enforcement related to meetings and gatherings of council members. And this was a similar one where the previous language, I believe, had discussed council meetings, and the council replaced it with gatherings to cover a kind of the wider nature of what they do. And now we'll just have a brief comparison between the district's open meetings laws. So in the Sunshine Act, all meetings at which official action is taken are open to the public. The Open Meetings Act, all meetings are open to the public unless there is an applicable exemption that permits a public body to have a closed session. And we'll discuss this a little bit more later, but those are contained in DC Official Code 2-575B. And also public body meetings covered and are specifically defined as a quorum of the members assembled to consider, conduct, and advise on public business. Under the Sunshine Act, there are no notice requirements, but it requires that the public have access to the government's meetings. By contrast, the OMA requires public bodies to issue a notice of the meeting no less than 48 hours or 2 business days prior to the meeting, whichever is greater. The Sunshine Act requires transcripts of all meetings and that the transcripts be made available upon request to the public. And the Open Meetings Act requires that all meetings be recorded by audio or videotape. If not feasible, then the meetings must be accompanied by detailed minutes. The language in the Sunshine Act and open meetings infer that a citizen may bring a lawsuit under the Sunshine Act. That's in DC Official Code 2-579A2. Whereas the Open Meetings Act provides mechanisms for the Office of Open Government to enforce the provisions of the legislation, but does not provide a private right of action for citizens for violation of the OMA. Just going to pause there briefly before we move on to the trending topics to see if there are any questions in the room or in the chat.
Sorry, so your office could have always brought a suit for Open Meeting Act violations, or was that the amendment?
So the question was whether our office always had the ability to bring lawsuits for violations of the Open Meetings Act, and that is correct.
Okay.
So I picked these four kind of, I call them OMA trending topics because these are kind of the issues that we tend to see most often or that we receive the most questions about. And they are regarding closed sessions, recording requirements, email exchanges, and public comment. These are not necessarily in order of which we receive more, although I will say the closed session issue is one that we probably do encounter the most frequently. Okay, so closed/executive sessions. Um, Closed portions of a meeting may occur pursuant to DC Official Code 2-575B. And here is a list of some of the justifications for closure. For instance, court order or statute, contract negotiations, attorney-client privilege, trade secrets, testing and grading, training, deliberations, investigations, personnel, and public health and safety. And the full list is contained at 2-575B. Okay, for a closed session, notice should include, if feasible, a statement of intent to close the meeting or any portion of the meeting, including citations to the reason for closure under 2-575B, and a description of the matters to be discussed. Closure in a meeting must include the OMA citation from DC Official Code 2-575B, the justification for closure, and a description of the matters to be discussed. So we're going to talk a little bit about the protocol for entering a closed executive session, and this is how we train and direct public bodies in the District of Columbia to go about the process in a way that we believe provides the most transparency to the public. So first, we advise that they open the meeting, establish a quorum, and open the meeting to the public, and conduct any business on the agenda for the open meeting, and then move to enter into a closed or executive session with a motion that includes the OMA citation to justify closure, and take a roll call vote, and if the motion passes, enter into closed or executive session. While in the session, the public body should only discuss matters that are referenced on the agenda. They should record the executive session separately from the open session, and then return to the public session after the conclusion of the closed portion, and where appropriate, report publicly any official action that was taken in closure before adjourning. Okay. Next, these are the recording requirements under DC Official Code 2-578. So all meetings shall be recorded. This includes open and closed sessions. We get that question frequently as well. Most public bodies don't have an issue with recording the open session, but we do get questions about whether or not they have to record the closed session. They do. That doesn't mean that it is automatically available to the public, but there needs to be a record of the closed session. So only where recording is not feasible, then in that instance, detailed meeting minutes shall be taken. Copies of records shall be made available for public inspection. This includes minutes, the full record. For minutes, it is as soon as practicable, but not later than 3 business days after the meeting. And there is an exception here for public charter schools, which get 30 business days to do so. For the full record, it is as soon as practicable, but no later than 7 business days after the meeting. Here are the publication requirements under DC Official Code 2-578. Draft detailed meeting minutes must be publicly available no later than 3 business days after the meeting. A notation must be included at the top of the document that detailed final meeting minutes will be posted to the website on the next meeting date. And audio recordings, video recordings, and transcripts. A copy of the full record to be made available no later than 7 business days after the meeting. Another popular question is about email exchanges. A public body is not permitted under the OMA to vote on public business via email. Email exchanges between members of a public body shall not constitute an electronic meeting. That comes from DC Official Code 2-577C. Another perennial favorite in the open meeting space is public comments. So there's no public comment period required by the OMA or its regulations. That being said, public bodies enabling legislation may require it to provide a time for public comments. Additionally, a public body's bylaws may also allow public comment, or there may be a standing order permitting public comments. And parliamentary procedure manuals such as Robert's Rules of Order may provide guidance on public comments. And we've included this because many times members of the public will come to the office and say, hey, they didn't allow me to speak. And that's not something that is covered by the Office of Open Government. Now, it may be an issue that they can raise with the body itself if the body's own regulations require it to give members of the public time to speak. But again, that's not something that is covered under the OMA. And then here's just a little tidbit about parliamentary procedure. So the Director of Open Government may provide advice and training on parliamentary procedure upon request. That is, as was mentioned earlier, that's going to be one of the sessions at the end of the day. It will be at 3 o'clock. But in general, if any public bodies need help with parliamentary procedure, our office is glad to provide that, including by giving access to the Robert's Rules Made Simple portal. There's a link contained here as well as a QR code. And so if you need training in parliamentary procedure, there's a number of videos there that you can access. And of course, if there are any questions or additional support that's needed in that space, you can contact our office. Yes, question in the back.
Yeah. What if the public body only wants to have a closed session? So it's they want to meet, but the only business is closed session.
In that regard, like our advice in general is still that. Oh, sorry, I'm going to repeat the question. So the question was, what if a public body only wants to have a closed session during that time that they're meeting? We still advise that they go through the process as was outlined in the presentation. There's nothing wrong with them conducting the entirety of the business that they need to conduct in closed session, but we still advise that they open at the beginning, state the reason under the statute why they're closing that session, give a brief description so that the public is at least aware of what is being discussed at that point, and then they would go into that closed session. And at the conclusion of that, if there were anything that needed to be reported out to the public, they could then do so and then just adjourn. But it is totally fine if that entire period in between is taken up by the closed session.
And I missed it. What happens about the minutes from the closed session in terms of availability for the public, or is the public allowed to request it, or what happened, and can they deny that request?
The public is allowed to request.
They don't have to provide,
but they do not necessarily have to provide them.
And the last question, you mentioned in emails there was that the committee, the public body can have emails. Can they have a group email? So all the committee members, can they have emails together, or is it just like one member to the other? Are you going Tuesday?
So The question was whether or not members of a public body could just have like a large email chain in which they're communicating with each other. Um, the members of a public body cannot conduct public business via email. Um, so nothing that would qualify as public business can be discussed like solely in an email chain. Obviously, if they're doing something like the logistics of planning, like, when they're available or that kind of thing, of course they can email each other with regards to that, but no public business should be taking place via email exchange. All right, I don't see any more questions in the room or in the chat. And so we're coming towards the end of my presentation. I did just want to mention that what we discussed today was a little bit different from our typical OMA trainings, in which we get more in depth with all of the requirements of the law. So one, if you are curious, I would advise you to go to our website and check out some of the previous trainings that we've given. Additionally, we have the following upcoming trainings. There will be an Open Meetings Act training on November 20th, which I will be conducting, as well as an Open Meetings Act training for boards of trustees for DC public charter schools, which will be on December 10th and is being conducted by my colleague, Joan Lelma. Here's the contact information for our office. You can reach all of us through the open.gov office at dc.gov email address. We all have access to that. Additionally, that is the number to the office. Or if you have specific questions for any members of the Office of Open Government, our individual emails are listed here as well. All right. So I know I went through that rather quickly, but I hope that was informative for everyone. And again, I'm available if there are any questions about what was discussed today, and these slides will be available to you all at the conclusion of that.